So thank you so much for joining us for today's webinar, part of our special CLCQ flood webinar series for 2022. This one is an employee's workplace rights when the water rises. My name's Carly Hanson and I'm one of the sector sustainability coordinators at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, Meanjin, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and as well some people outside of Queensland, I'd also like to pay respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are joining in on this webinar today. So today I'm really pleased to welcome our presenters Edmund Burke and Ayana O'Mara, who are partner and lawyer respectively from Holding Redlich Lawyers, who have generously provided their time to present today's session. So the session, as I mentioned, is around workplace rights for employees during these times of floods in southeast Queensland and northern New South Wales. And as we know, many businesses are struggling to stay afloat after the floods, which means that workers can find themselves in a bit of a difficult situation potentially with their employment. Human resources bodies in organisations might be grappling with soggy work premises, a shortage of work and possibly stranded employees. Before employers opt to terminate employees, flood-affected businesses should consider several options that can help track their way through these troubled waters without sacrificing workers. Considering use of things like accrued leave entitlements, temporary stand down of employees and alternative duties can sometimes lead everyone back to dry land unharmed. So I'll let Edmund and Ayana tell you a bit more about themselves in the session when I hand over to them in just a moment. But before I do that, some quick housekeeping. So today's webinar is being recorded and I'll have the recording available for you to download later this afternoon or tomorrow. The PowerPoints have been emailed out this morning and also uploaded to the handouts section of the GoToWebinar control panel if you'd like to download those. We'd really encourage you to ask questions while we've got our experts in the virtual room. So simply type your question into the question box on the control panel and I'll read your question out for our presenters at the end of the session. So I might now hand over to Edmund and Ayana to take us away in today's session. Thank you so much, Edmund and Ayana.
Thanks, Carly. Edmund Burke is my name here. I'm a partner at Holding Redlich in the Workplace Relations and Safety team. And I've got Ayana O'Mara, who is an associate in our team. And today's presentation is obviously about workplace rights after, during, around natural disasters. And we've had a bit of experience of that in recent times and with COVID-19 as well. So there are things that both employers and employees can do that can get them through to the other side relatively undamaged. And we've tried to sort of go through various scenarios in this presentation. I should just say a disclaimer at the beginning, all the silly photographs are my fault. And we're certainly not making fun of the situation, but I guess sometimes if you don't laugh, you cry. So if anybody is offended by the photographs, I apologize. They are meant to be funny. If I could just respectfully acknowledge the traditional owners of the land on which we're speaking to you from, the Turrbal and Yagara people. As the continuing custodians of this land, I recognize their continuing connection to country, practices, knowledge systems and communities. I also acknowledge the traditional custodians of the lands on which each of you are living, learning and working from today. May we also pay our respects to elders past and present and Aboriginal and Torres Strait Islander peoples who may be here today. So the slide there is just an overview of what we've gone through in this presentation. So we have various topics. What if an employer has to temporarily close, which is obviously quite relevant following the floods. Alternatives to standing down employees, which is normally or quite often the first reaction of an employer. questions like, are employees able to take leave, take care of themselves or their family? Then we talk a little bit about health and safety, and what you do and do not have to do as an employer and an employee following a natural disaster. Employee concerns, things like if the employer wants to reduce your pay, if he wants to redeploy you, or if she wants to make you redundant. It's really, an employee does have some rights in those circumstances, and sometimes they have the opportunity to make a suggestion that could resolve the situation in a better way for everyone. Then we go a little bit into the types of employees and the different rights and entitlements for different types of employees. And then just a bit of an off-the-wall one. If you signed a contract and are, say, due to start on the Monday and a natural disaster hits and the job's gone. And then at the end of the session, we'll take any questions that people have, and I guess just take it from here. So first silly photograph, which isn't really silly, Toombul Shopping Centre. It's probably a very, very good example of a situation after a natural disaster when an employer has no opportunity to stay open, and they do have to temporarily close. And I'll just hand over to Ayana to take us through this stand down provisions of the Furlough Act.
Thank you, Eddie. So when an employer simply has to shut up shop, there are different options they may consider, one of them being a stand down. So leaving casual employees to one side for the moment, where an employee is ready and willing to work, it is the employer's responsibility to provide the work or pay wages if work cannot be provided. So stand down is an exception to the employer's obligation to otherwise pay wages, and broadly it covers situations where an employer cannot provide work due to circumstances beyond its control. If an employer decides to stand down an employee, they just aren't required to pay wages. So an employer does not have an automatic right to do this. So where an employer is trying to, the first step to resisting a stand down is to really confirm what an employer is relying on in order to try and do a stand down. And without an automatic right, an employer must rely on stand down enabling provisions contained in either an enterprise agreement, a contract of employment, or the Fair Work Act, which we have a provision up on the screen. Before going into the Fair Work Act, where an enterprise agreement or a contract enables an employer to stand down employees in the same circumstances, an employer must rely on those particular clauses instead of the stand down provisions in the Fair Work Act. So under section 524 subsection 1C of the Act, an employer may stand down an employee without pay if there is nothing useful for an employee to do during the stand down, and the reason for that is a stoppage of work for which an employer cannot reasonably be held responsible for. So while flooded premises may justify this, careful consideration should be given to whether there has been a stoppage of work, whether the cause for the stoppage was for the relevant reason, being a reason that the employer cannot be reasonably held responsible for, and whether the employee could usefully be employed because of that stoppage. So a stoppage of work requires a complete cessation of activity. A simple disruption to work or a reduction of work won't suffice, and only the work needs to stop, not the business itself. So different operations within a business may be affected differently, but where the business cannot trade at all, despite some limited administrative work being able to be performed, a stand down may still be appropriate. So under the Fair Work Act, implementing a stand down is entirely an employer's decision. There are no specific requirements to provide an employee any notice of the stand down or consult about the intention to do so beforehand. However, a modern award or an enterprise agreement may have separate consultation clauses for major workplace changes, and those clauses may apply to require an employer to consult with or notify employees of a decision to implement a stand down. So The alternatives.
So I might just jump in there. We have had clients come to us as well trying to retrospectively stand down employees. So it just hasn't occurred to them at the time. The employee hasn't been able to work. And then when they come to the payroll at the end of the month, they decide that actually those days were days when the employee was stood down. You're not strictly speaking allowed to do that. And if an employee hasn't been given notice that they're stood down, they're entitled to feel that they're being paid wages for those days that they haven't been able to work.
Thank you, Eddie. So the alternatives to a stand down, I guess in the photo we have them sitting down. So while stand down should really be used as a last resort, it would seem that depending on the provision being relied on, there may not necessarily be anything to require an employer to exhaust other options first. So if an employee is faced with a stand down, they should really consider suggesting alternative options that would have the effect of receiving an income in some way. So one of those options is looking to access accrued annual leave for the time of the business closure. We have a little flowchart on the screen that can set out how to approach this. And from a starting point, the selling point to suggesting accessing annual leave is that it's an opportunity for the employer to reduce the accrued annual leave on their books. So if they can do it by agreement between employee and employer, that's probably ideal. Now, whether an employer can force an employee to take paid annual leave will largely depend on whether a modern award or enterprise agreement applies. So where an award or agreement applies, certain awards and agreements may contain a shutdown clause, such as a clause requiring an employee to take annual leave when an office is closed for Christmas, for example. So where those clauses are available and applicable, an employer can require an employee to take annual leave in accordance with them. Where the award or agreement applies but lacks a shutdown clause, an employer may not necessarily be able to direct an employee to take accrued annual leave. Now, depending on the enterprise agreement, an employer may be able to incorporate and apply any available shutdown clauses from an underlying modern award. However, where the award is silent altogether, the only option is for an employee to agree to take the leave. So then turning to an award-free or an agreement-free employee, Section 94, subsection 5 of the Fair Work Act allows employers to require the employee to take annual leave if the requirement is reasonable. Now, that reasonableness restriction also applies when attempting to rely on a shutdown clause on the other side of that tree. Whether or not a requirement to take leave is reasonable will involve consideration of a number of things. So that can include the employee's needs, the employer's business needs, any agreed arrangement with the employee, the custom and practice in the business, matters pertaining to the direction itself, such as the timing of the direction and the reasonableness of the notice given to the employee to take leave. So another alternative, a couple of alternatives really involve the employee working in some way. Now, I've just got a couple of examples listed here. It might include a flexible working arrangement, same work in a different location, or even working in a different role to some extent, but Eddie will go into a bit more detail about that later on in the session. The next question that's worth looking at is whether employees are able to take leave to take care of themselves or their family. The short answer is yes, but depending on the circumstances. So leaving aside any unique entitlements under an award, an agreement, or even a particular employer's policy, under the national employment standards, there are options for carers or personal leave. Even more broadly, there is community leave available to assist the community depending on the circumstances. But focusing on carers leave or personal leave, there is an entitlement to 10 days paid leave for each year of full-time service, and that's available to all national system employees except casual employees. So this paid leave can apply when an employee is providing care or support to a member of the employee's immediate family or household who requires that due to a personal illness or unexpected emergency affecting the family or household member. So an example of that can include where an employee has to suddenly care for their child because their child's childcare has closed due to flooding. So the 10 days paid leave is also available when an employee is not fit for work because of personal injury or personal illness to themselves. In a flooding situation, that may include an employee who finds themselves unfit for work because of an illness contracted when cleaning up flood damage, for example. So under the NES, there is also an entitlement to 2 days unpaid leave. It's available to casual employees. It is also available to national system employees where the 10 days pay leave or where the paid leave itself cannot be taken. It's available on each occasion as when the paid personal or carers leave would otherwise apply. So subject to any unique requirements, an employee needs to provide notice of the leave to their employer as soon as practicable, but that notice can be given after taking the leave. So really an employee, they should still obtain the evidence supporting the reason for taking the leave, just in case an employer decides to ask for it. Now, where an employee has been stood down and seeks to access accrued leave, they may not be entitled to be paid for that leave unless it's otherwise being authorised by their employer. And now I will pass it over to Eddie.
Thanks, Diana. So the next slide that we have there is health and safety, or do I have to be a hero? And look, the short answer is no, you don't have to be a hero. You don't have to do something that makes you feel unsafe or places you at risk. But obviously, the reality is in these types of situations, an employer may ask you to help out with certain tasks that you wouldn't normally be involved in. And it's important that you know what your, well, both employers know what their health and safety obligations are, and workers know what risks they should take and what risks they should not take. And when they're entitled to say, this is not safe and I don't want to do it. At a minimum, employers need to consider questions such as, is it actually safe to travel to the workplace? So say, for example, you're an employer, you need somebody at the workplace, but the roads are cut off and you're arguing, well, that's fine, you can drive through, the water's not that deep. They are absolutely wrong in that situation, and you are entitled to say, it's not safe, I can't come to work. Things like, can the workplace be safely accessed at the moment? Obviously, in the case of, say, fire damage or flood damage, it may be that the actual workplace has been damaged and it's not safe. And certainly in those circumstances, you are not obligated to turn up and start cleaning up when you don't feel that it's a safe environment to do so. Additional risks, obviously, from floods or fires, even things like slippy floors, things like mud, debris, unsafe buildings that may have suffered such damage that they could collapse. And you're not, we had a picture of the Rock there earlier, you don't have to be like the Rock and rush in and start being a hero. If you don't feel safe, you don't have to do it. And there's also the question of whether the work itself that you're being asked to do is suitable for you or for somebody in your role. So things like, are you being asked to undertake sort of new, different or undefined tasks? The types of things that, you know, come to mind are, you know, cleaning windows, cleaning gutters. You know, there might be a big pile of rubbish that you're being asked to load into a skip. And in some circumstances, it might be suitable for you to do that, depending on what your role normally is. But say, for example, say for in a shopping market, for example, if you're somebody that's you know, elderly or older that normally does administrative tasks, that might have an illness or disability, and if you're being asked to come in and engage in physical work, you are entitled to say, look, I can't do that. And you shouldn't put yourself at risk in order to pitch in when you don't feel that it's suitable. You may be asked to do some kinds of tasks that you really should have training for before you engage in them. Like I said, things like cleaning the gutters, or working on plant in a workplace that you wouldn't normally work on. You don't have to do that, and if you don't think you have the sufficient skills to do so, you really shouldn't be doing that. And it's definitely an entitlement on the part of the worker to point this out to their employer and to tell them that they feel it's not safe, and the employer has an obligation under the Work Health Safety Act to provide a safe place of work. And even in circumstances like a natural disaster, people naturally want to pitch in and help out. It's important to be aware of work health safety, even in these circumstances. The question of whether it's safe to travel to work, we talked a little bit about that earlier. There are things that an employer can do to reduce the risk. They may, for example, have a bus that they send around to get their employees to work, or there may be some other ways of getting their employees to work. And employers should be looking at things. If they do need the workforce to come in, they should be looking at ways to eliminate risks, substitute things for the normal practices to allow risks to be reduced. So that little pyramid there on the side is something that's often used in work health safety matters. It kind of it illustrates what's called the risk pyramid is. So the first option is you eliminate the risk if possible. Second one is you substitute something to reduce the risk. You might engineer something to reduce the risk. So, for example, in a situation where, for example, you're being asked to work on a dangerous piece of equipment, it may be that rather than even use that equipment, they use something else that doesn't need maintenance. Administrative controls can be things like having a system set up where workers are getting text messages to tell them that the office is open, the workplace is open, or that the workplace isn't open, or just alerting them to things in real time. There might be a storm on the way, for example. You could advise your employees to get home before the storm hits. Other things then, like PPE, which is a term we've all become a lot more familiar with after COVID. In a situation like a flood, it might be just providing you with Wellington boots, but there are lots of options to make certain tasks safer if you're being asked to engage in them. Now the next question obviously links up with that. We've got Forrest Gump and Bubba there cleaning the floors with toothbrushes, and that's not a reasonable request. If your employer wants you to do that, you should say no. But if the work that the employer requests you to do is lawful and reasonable, it may be that you do have an obligation under the terms of your role to actually help out. And again, that depends on factors such as your skills, experience, health, any disabilities you might have. And again, we've gone through specific safety training, equipment and procedures. While you're at work, your employer is required to ensure yourself health and safety, and that applies in absolutely any circumstance. You can't be directed to perform work that is unsafe or where you do not have the necessary safety equipment and safety procedures in place. So there may be some tasks that it would be perfectly safe for you to do if that equipment was available, but if the equipment's not available and your employer is asking you to do the task regardless, you are entitled to say that's not lawful and reasonable. I don't feel safe doing so. The next slide then asks the question, if I work additional hours because of a disaster or an emergency, do I get paid overtime? And the short answer is you should get paid overtime if you would normally get paid overtime. And of course that will depend on contracts of employment, your award or your enterprise agreement. You may also be entitled to payments such as working overtime, as I said, or things like meal allowances. And it's important that people, in any circumstances, if they are covered by an award or an enterprise agreement, familiarize themselves with it, because that is the best way of protecting your rights as an employee in this circumstance and any other circumstance. If you're being asked to do something that you feel is unfair or that you feel is taking advantage of you, it's worth checking the award to see if there's something in there that means it's not lawful for your employer to ask you to do it. Now that little screenshot on the right is from the Fair Work Commission site, and there is a tool on there where you can go in, answer a few questions, and they'll tell you if you are in fact covered by an award. Obviously, if you have a written contract of employment, you should check that for any relevant provisions in terms of your overtime or any specific provisions around things like natural disasters. And it's also the case that if you earn a salary, like a lawyer, for example, you're not going to be entitled to overtime and allowances. If the direction is lawful and reasonable, then it is something that you are just going to have to do in these circumstances. Now, another reaction from employers that can sometimes be legitimate is they'll want to reduce your pay until they get through a difficult period. Now, reducing an employee's pay in normal circumstances always requires the employee's consent. And certainly just at a very basic level, any employee that's asked to accept a reduction in pay should be checking that they are at least getting paid the national minimum wage, which is currently $672.70 for a 38-hour week. And again, you should consult your award, your enterprise agreement, just to make sure what your minimum pay and entitlements are. Because often an award obviously will have a pay scale for somebody in your position, and it may be well above what the national minimum wage is, and you are still entitled to that minimum pay in any circumstance. I've got a case there on the right-hand side of the slide, and it doesn't relate to a natural disaster, but it does relate to an approach that was taken by a business who was going through some cash flow problems. They approached their staff, asked them to accept a 10% pay cut, basically to save their own jobs and to save the business. Most of the workforce agreed. Obviously, some didn't because they ended up in the commission. And Senior Deputy President Hamilton fined for the business and said, this is a legitimate course of action taken by the employees and employer, and no criticism should be made of it in my view. Indeed, it might be said that it appears to be the sort of joint effort by employees and employer which should be encouraged by this tribunal. And that can be the case after a natural disaster. It may be that it's perfectly sensible for an employer who's trying to save the business and, by extension, everybody's job, to approach the employees and ask them to accept a pay cut for a short period of time in order to get over that hump. Obviously, you need to watch out for your pay being reduced and never going back up again. And you need to make sure that you are, at the very least, getting your minimum entitlements. But in some circumstances, it makes sense, and it may be that it's something that, as an employee, that you should consider, because in the long run, it's going to work out better for everyone. Redeployment is on the next slide, and Ayana spoke a little bit about that earlier. Now, redeployment obviously means being moved either to another area of the business or even an associated business for a period of time until the normal role is available again for you to take up. And if a disaster means your job simply no longer exists in that location, for example, just harking back to Toomble Shopping Centre, who knows if that's ever going to reopen, but most of the outlets in there will have other outlets in either in other shopping centres or other locations, and it may be perfectly reasonable for an employee to say, well, you don't need to terminate me or try to make me redundant. There are other roles that I can do within the organisation. You can only be redeployed to another role as an alternative to a termination of your job if it's contemplated by your employment contract or if you expressly consent to this. So what that means is, if it's the employer that's wanting you to do this and you don't want to do it, if there's nothing in your contract that foresees this, it may be that you don't have an obligation to accept. Alternatively, they may approach you, it may be an attractive option, and if you consent to it, then it's perfectly legal for them to do it. If there is no consent and the employer just goes ahead and tries to redeploy you, that can amount to what's called a repudiatory breach of the contract of employment, and it can result in a claim for damages for breach of contract. Now, obviously, in some circumstances, that's not going to be suitable, but in certain types of jobs, it can be, and it can be a way, I guess, to maximise any termination entitlements that you have if your employer is trying to terminate you unlawfully. Which leads us on then to redeployment and unfair dismissal. So the concept of redeployment is actually expressly referred to in the Fair Work Act, and the section provides for remedies in relation to unfair dismissal. That's part 3.2. A person's dismissal won't be a case of genuine redundancy. So often in these circumstances, the employer will come to you and say, look, this simply isn't a job for you here anymore. We're not going to be able to open for the foreseeable future. I'm going to have to make you redundant. And it may be that it's not a genuine redundancy. They do intend to reopen in a few months' time. It may be that they're calculating that they'll be able to employ all new people on a lower wage. And in those circumstances, it does leave open the option of an unfair dismissal claim. If you've been reasonable in all the circumstances, you've been able to suggest a redeployment, or you're aware of a redeployment option, and the employer is simply not offering it to you because the reality is they want to basically clean out all their employees and start again. You do have an entitlement to be redeployed as an alternative to redundancy within the employer's enterprise or within an associated entity of the employer, and that's a right that is actually in the Fair Work Act. Now, obviously, there are conditions, there are matters that can be relevant about whether a redeployment is reasonable, and those are things like the nature of any available position, qualifications that are required to perform the job. So if you're employed as an electrician, you can't insist that you should be doing the job as a plumber over in the other location, and that obviously relates to your skills, your qualification, and your experience. And the location of the job in relation to your residence or your current role is also important. It doesn't make much sense if the only offer of redeployment is in another city that's maybe 2 or 3 hours away, or somewhere that just simply isn't feasible for you to get to. That's not going to be a genuine offer of redeployment. And again, then the remuneration. So if you're being offered a job, a position as a redeployment that's much lower paid, you don't have an obligation to accept that in most circumstances. And this next slide is just having a quick look at some complicated issues, which is the type of employee that you may or may not be. Obviously, everyone's heard of the casual employer, the independent contractor, or just a permanent, either full-time or part-time employee. We've spoken a little bit earlier about the entitlements that an employee has, things like personal leave, annual leave, and so on. An independent contractor is in a position where they normally don't have any obligation to be provided with regular ongoing work unless that's agreed in the services agreement, and that's unusual to the extent that a genuine independent contractor has to be able to work for other employers if they feel like it, if they want to, it's fairly unusual to find in a normal independent contractor services agreement an absolute guarantee of work. As an independent contractor, you wouldn't have any statutory entitlements such as annual leave or any other type of leave during a natural disaster, and you bear the risk of the quality of your own work, and you're also responsible for your own insurance. You'd normally have things like your own equipment. So say, for example, if you're a truck driver, you might own the truck. The advantages of being an independent contractor in a natural disaster situation might be that there may be work available for a completely different employer elsewhere that under normal circumstances, your main employer would not allow you or permit you to go and work for. But as an independent contractor, if the person that you're normally invoicing every month isn't able to provide you with work, you have a right to go and find work elsewhere. So it does give you that freedom, but obviously you don't have all the safety nets that you would have as a permanent or part-time employee. Casual employee gets quite complicated. We all know what the term means, and generally it's when you only get work when your employer gives you a shift or puts you on the roster. You tend to work irregular shifts, and your hours should change from week to week. And if you're a casual employee under an award or enterprise agreement, you should at the very least be paid rates which include a casual loading, which is intended to cover the loss of those things like sick leave that you don't have as a casual, or certainly don't normally have the same way as a permanent employee. Now, I've put in the concept of the casual conversion here because it may be that some workers have just gone through a natural disaster, have found that they've been out of work for a number of weeks and they don't want to find themselves in that same position again. And many casual employees actually, although they're characterized as casual employees at law, they may be permanent employees. And the Fair Work Act does recognize this in a number of ways, but probably the main one is the obligation on the part of a larger employer to give their casual employees the offer to convert to permanent part-time or full-time, basically on a 12-month basis. Now, that's only for the larger employees, so the small business employer doesn't have an obligation to make the offer, but there are certainly ways to achieve that with the small business employer as well. There are eligibility requirements. So to be eligible to make that casual conversion request, you need to have been employed by that employer for at least 12 months. You need to have worked a regular pattern of hours on an ongoing basis for at least the last 6 months. Now, regular pattern of hours doesn't mean that you work exactly the same hours every week. What it might mean is, for example, over a 2-week period, the first week you might work a Tuesday, Wednesday, Thursday. The next week you might work a Friday, Saturday, Sunday. That's still going to be a regular pattern of hours over that 6-month period, even if it does alternate that way week by week. And if you are in that situation, and if you could continue working those hours as a full-time or part-time employee without significant changes to your role or to the business, then chances are you are entitled to become a permanent employee and have the entitlements that permanent employees have. Now, the small businesses, so a small business is an employer that has less than 15 employees or 15 or less. They're not required to offer casual conversion, but you can still ask. And once you ask in writing, they do have an obligation to write back to you within 21 days and either tell you whether they have or haven't accepted the request. They can't refuse the request unless they have at least spoken and consulted with you, and they must have reasonable grounds to refuse the request. So reasonable grounds means things like they're able to tell you that in 6 months' time that position won't exist because of plans, restructuring, whatever it might be within the business. They can't just pluck that out of the air. They have to be able to back it in. But certainly if that's their position and it's legitimate, that's a reason not to convert. They could argue that the hours of work would need to be significantly reduced to allow you to work as a full-time person. Maybe that's because of the extra expenses in a full-time employee. For example, they may argue that the days or times of work would need to significantly change, and that can be accommodated within the days that you're available to work. They might say, for example, they'd have to make a significant adjustment to your hours for you to be employed in that type of role. The key thing to remember is all of those arguments can be legitimate, but they need to be genuine, and they need to be, as I said, not just plucked out of the air. There needs to be something that they can put to you that backs it in. And then just the final slide there, that is a picture of Bad Luck Brian, who's an internet meme. He's sort of famous for being extremely unlucky. And a scenario, for example, you've just won your dream job, you've been given a contract, you've signed the contract, you're due to start on Monday. On Friday, there's a flood or a bushfire, and the workplace is destroyed, or probably more applicably, the workplace is damaged, and they look at it and they say, look, we're not in a position at the moment actually to start hiring people, so let's just go back to Bad Luck Brian and tell him that we're withdrawing the offer. Now, an employer can withdraw an offer of employment at any point before it is accepted, and they can do that without giving notice or make a payment. But once you've signed the contract and you've fulfilled any preconditions, things like your references have been checked out, your qualifications have been confirmed, then the contract's in place. So even if you haven't started work yet, you still have a contract of employment that can't just simply be cast aside. The employer, instead of just withdrawing the offer in that circumstances, has to terminate the contract. And most, if not all, employment contracts will have a period of notice. And obviously National Employment Standards will have a minimum period of notice as well. And in those circumstances, Bad Luck Brian would at least be entitled to his notice in lieu. And failure to do that could give rise to a breach of contract claim. In normal circumstances, the employer's liability is only going to be for the 4-week period, or if it's actually a week before you were due to start work, they're only going to have to pay you for 3 weeks in terms of notice. But if your contract is for a more substantive role and it contemplates a longer period of employment, contemplates promotion, a new title, increase in pay, things like that, it is possible, and it could be worth your while going to court, and it is possible that the court then would factor in that loss of opportunity, the future employment that you were expecting, and you could end up with quite a large award of damages, depending on the circumstances. You would need to be extremely unlucky for that to happen, but I'm sure it does happen, it has happened in the past. And that is the end of the presentation, and thank you for listening. We're going to try and get our camera on so that we can answer any questions and you can see our faces.
Wonderful. Yes, we can see you. Thank you so much, Edmund and Diana, for that presentation. It was very thorough, and I'll now invite our attendees to ask any questions if you've got them. So please feel free to pop your questions into the question box on the GoToWebinar control panel, and I'll read those questions out. But in the meantime, I do have a couple of questions that came to my mind as you were walking us through that content. So I might, just to kick us off, ask a couple of those questions. So I guess in community legal centre land, we at the peak, it may have happened, but we didn't hear at the peak of any stand downs that took place. And in fact, although we did have a couple of our member centres impacted by the floods at their premises, often the employees were able to pivot to a work from home arrangement, which, you know, one bonus that has come out of things like the COVID pandemic, where many of those sort of technology arrangements were set up in our workplaces during that time to allow people to work from home. But I did wonder if, you know, in the recent floods where we had perhaps employees in the community legal sector whose homes were impacted by the floods, whether they could access personal leave in lieu of a stand down, if that was, you know, on the table, whether they could access that leave for mental health reasons as well as, you know, the other reasons that you sort of the other examples, I suppose, that you'd put into the slides around personal injury of the worker, or, you know, the lack of childcare availability, and so needing to take that carer's leave. So I guess I was curious about mental health impacts of the floods, because obviously that's come up and does come up in natural disasters from time to time.
Yeah, look, absolutely that they're entitled to access personal leave if they're experiencing high levels of anxiety or stress because of what's happened. Depending on the employer may require a medical certificate, and it seems a bit curlish, but some will. But most GPs will provide you with a medical certificate if you explain to them that you're suffering from anxiety or suffering from stress. It may be difficult to access a GP during or after a natural disaster. And I do think if an employer tried to contest what you're saying or query it or make an issue of it, that ultimately they'd come out on their own side of it. But certainly in practice and in theory, you are entitled to use that personal leave for mental health concerns.
Great, that's wonderful, thank you. Another question here. So I guess this one sort of hinges on the personal attributes of an employee. So where the workplace may be safe, the physical premises is safe for workers to attend, and the employer is requiring people to attend the office to do their work as they usually would during or post these floods or other natural disaster. But the employee has a particular disability or health condition, which would mean that they're not feeling safe personally to attend, could they be forced to attend, or what sort of suggestions would you, or options, I suppose, would you suggest for the employee and employer to work that sort of situation out?
Well, I guess there's so many different scenarios there, isn't there? I mean, it could be that an employee has suffered a mental health injury because of the natural disaster itself, and for that reason they can't go into the workplace, or they want to avoid the workplace. And I mean, really, if they can access their personal leave for a period of time, they can do so. And in a situation where they're simply not recovering and simply can't go into the workplace, I mean, the normal types of processes will apply, and depending on the employer and their attitude, you may at some stage find yourself being asked to attend independent medical examination to ascertain whether you are able to perform the inherent requirements of the role any longer. But if it's something that you're being asked to do specific to the natural disaster, and if you'd be happy then to go back to your normal role, I think in most circumstances you're going to be able to say to the employer, for whatever reason, whether it's a physical disability, whether it's a mental health issue, that you simply do not feel safe performing those tasks. Again, an employer, depending on the employer, they might decide to terminate you, but you would absolutely have an unfair dismissal claim in those circumstances. If we're talking about short periods of time, or simply being unable to deal with the aftermath of a natural disaster, I think it'd be very foolish for any employer to terminate somebody that's saying, I can't do those tasks, either for a physical reason, for a mental health reason, because ultimately you're dismissing them because of a disability in those circumstances, or a temporary illness.
That your answer just triggered another question for me. So if you were working from home, for example, so if you've negotiated that it is unsafe for whatever reason to return to the workplace to do your job, but you're able to perform your role from home, and you have an injury or an incident at home, what's the situation there for workers? Are they able to look into work cover or other kinds of arrangements if an injury occurs in the alternative workplace?
If you're injured at home and you're working, you'll still be covered by work cover. That's the workplace. If it's on the basis of an agreement with your employer, flexibility agreement, or if it's on the basis of something that's contemplated in your employment contract. If you're working from home without your employer's permission, then any injury you suffer, you wouldn't be able to claim for. But in the circumstance where you're working from home, you suffer a stress injury, say, and I guess it's important to qualify that in that if you're required to work from home, and if you're in a situation where you can't do so safely, and you've told your employer that, and you are then injured, I think you would be covered under work cover. But if it's a situation where you've been asked to work from home and you're working, say, you're sitting in your armchair, your feet up, with a laptop on your legs, and your laptop explodes and your legs get burned, I'm not sure how that would apply. But if you've done everything correctly, and if you have the proper setup, or you've had to go to the employer to ask for a proper office seat, for example, and they refuse to supply you with that, and you then suffer some sort of physical injury because of how you're set up ergonomically, if that's the right word, then I think you would be entitled to a work cover claim in those circumstances. Funnily enough, we do quite a bit of work cover work, and we haven't seen a lot of working from home injuries come through. And I don't know if that's because people don't realize that they are, in normal circumstances, still covered. But certainly, if you're sitting at your computer and performing work and you suffer an injury, you're going to be covered for that, arguably. But if, for example, you're working from home and at lunchtime you decide to go for a run and hurt yourself, probably going to be less likely that you can claim in those circumstances. So I guess that's not a very clear answer, but the reality is the closer your connection to work when you suffer the injury, the more likelihood is that you will be covered by work cover.
Wonderful, thank you. So Daniel's asked this question around employee contracts. So does the principle of frustration apply in an employment contract, notwithstanding the employee does all its obligations or all their obligations prior to actually commencing employment? So this is, I guess, related to that scenario you provided of the person who hadn't actually yet commenced work.
Yeah, look, I mean, the principle of frustration applies to any contract, pretty much, but it comes down to the practicalities of it. At employment law, you will have a breach of contract claim, but it may cost you more to make that claim than you're going to recover from the contract. And from the employer's point of view, yes, they may have a defense to any claim, but chances are defending the claim is going to cost them a lot of money as well. At law, if you've signed the contract and the employment of contract is in place, and in the circumstance where you could start work, it may not work for the employer financially or where they are right now, given that there has been a natural disaster, but you could work without destroying their business, then you will have a breach of contract claim. If, for example, you have an employment contract to work in a cafe and the cafe's being blown away, like that restaurant on the Brisbane River all those years ago, then, you know, frustration may apply in those circumstances because there simply isn't a workplace for you to go to. So it kind of would depend on the nature of the reason why the employer is coming to you to say, I'm not going to honor that contract. If it's because they would simply prefer not to give themselves more financial options given what's just happened, then you will have that breach of contract and frustration won't apply. But if, you know, the work premises have been blown away or just simply are uninhabitable, then yeah, potentially frustration would apply.
Great, I hope that answers your question, Daniel. And I might sort of do a last call out for questions, but while they're coming through, just one final question from me. So is there a limit in terms of time to the amount of time that an employee can be stood down for? Or could it just go on forever?
Well, look, the reality of a stand down is there isn't a prescribed period of time, but it's intended to be for a short period of time. And it's intended to sort of get through a situation, an emergency situation, rather than be a long-term thing. So if you've been stood down without pay and, you know, 3 months in, you're still stood down without pay, you'd have to ask why you're sort of hanging around, because, you know, the job is clearly not there any longer. And, you know, you're perfectly entitled to go and look for another job somewhere else. So it really would only become an issue if an employer, you know, was back on their feet, everything was going well, they had employees back in the office, there's no reason why you couldn't come back, but they're still trying to keep you on stand down. Then that would be an issue where you could say, look, this isn't legitimate any longer, and it's, you know, you can make an application for work if you had to. But in a circumstance where the employer is just indefinitely trying to stand you down, there's going to be another reason for that. Whether there's just not a job there any longer, or they don't want you to come back to work for some other reason. So there isn't a prescribed limit, but really it's only envisaged to be for short periods.
Great. Well, thank you so much. I might hold the questions there. And thank you again to Edmund and Ayana from Holding Redlick for your time and expertise in today's session. And thank you to our audience for your questions as well. So before I close the webinar down, I'll just remind attendees to please complete our feedback survey that will pop up at the end of the session once the webinar is closed. This really helps us to continually improve our webinar program. But for now, I'll say goodbye and hope to see you all at the next webinar in our CLCQ series. So thank you so much and have a great day, everyone. See you later.
Thanks.